Hello, everyone. My name is Noah Novogrodsky, and I am a professor at the University of Wyoming College of Law. I'm going to be talking today about a case playing out at the International Court of Justice, which may be of interest to people in Wyoming, the mountain west of this country, and really all over the world. This presentation is accessible to non-law students, to scholars of international relations, and to everyone interested in the importance of water. Okay, there is an important legal proceeding developing at the International Court of Justice, which is based in The Hague in the Netherlands. And it is a case involving two countries in South America, Chile and Bolivia. And it concerns a tiny 5-mile-long, 8-kilometer-long river called the Silala River. The waters of the Silala River bubble up from an aquifer beneath both Chile and Bolivia. And they emerge in Bolivia and flow downhill into Chile, where Chile pipes the water 400 kilometers away to a copper mine and uses the waters of the Silala, as it has for more than 100 years, in the industrial application at the mine. Importantly, there is almost nobody who lives in the region of the Silala River, in the high desert at almost 17,000 feet between Bolivia and Chile. Very little grows in this area, and Chile is taking the water in a place of great dryness and aridity and using it in a mining operation far away. Why did Chile sue Bolivia in this context? It is because Bolivia and Chile have had a number of controversies between the two states, most significantly over access to the Pacific Ocean. Bolivia actually sued Chile at the International Court of Justice because it wanted to revisit or reopen a treaty it finds unjust from the 19th century. Bolivia was unsuccessful in that case. And what happened was that Chile was able to convince the International Court of Justice that its current and present boundaries should continue to operate and that Bolivia would remain landlocked. Bolivia was unhappy with this reality and began to object to the historic and traditional use of the Silala River that flows from Bolivia into Chile. Chile did not want to be sued again. Chile wants clarity over its water use. And so Chile sued Bolivia at the International Court of Justice before it itself could be sued. And Chile is seeking a declaration from the International Court of Justice that its use of the water is proper and that it can continue to use the water going forward. Chile is basically saying three things. Number one, that it is a river that flows from Bolivia into Chile, and that it is therefore a transboundary watercourse, which is a term of art to describe a river that is not contained entirely within one country and that crosses borders. There is an international convention governing transboundary watercourses, and if it is deemed to be a river and not a wholly, say, Bolivian lake, then Chile wants this international law to apply. Second, Chile believes that traditions and customs governing international rivers ought to apply to this controversy. And specifically, that there is a customary international law that applies when water flows from one country into another. The custom here is that each country may equitably, fairly, and reasonably use the water found in its territory. Now, all over the world, there are disputes over what exactly that means. But Chile's position is that they want to be able to continue using that water which flows into Chile, however Chile decides it ought to be used. Bolivia disagrees, and Bolivia's position is that this is not really an international river, and that the history matters, but it matters in a different way. So Bolivia objects to how this river has been utilized historically. In the 19th and early 20th century, a British company built railroads and canals in both Chile and Bolivia. The Bolivian government of the early 20th century gave a concession to this British company to use land, railroads, and water in ways that the company was seeking primarily in the mining industry. That concession expired in 1997. So essentially, Bolivia had given Chile and this British company rights to use the water of the Salala River. That much is not in dispute. But in so doing, the British company built some channels or canals that facilitated the flow of the Salala River downhill from Bolivia into Chile. And remember, once it gets to Chile, the water is piped to the copper mine far away. Bolivia takes the position that if these canals had never been built, that the water would have remained in Bolivia, forming something like a highland ecosystem and even a wetland, more like a lake than a river. And so Bolivia's position is that it's A, not a river, and B, that it is being forced into Chile. Bolivia further argues that Chile should pay compensation to Bolivia for the past use of the water. And finally, Bolivia argues that it should be able to do whatever it wants with the water in the future. And that going forward, Chile should no longer take advantage of these 19th century canals that draw the water into Chile. So we have two positions here. They disagree on the description of what it is. They disagree on the legal standard that should be used. And they disagree on who owes whom what going forward. The International Court of Justice has agreed to hear this case, and it will be heard in April 2022, and much of the world is watching a case concerning an obscure tiny stream or river from Bolivia into Chile. This case has the opportunity to clarify international law concerning water. And how the International Court of Justice rules is going to be important. There are some things that are not in dispute, and it's important to recognize what is not being argued here. Number one is if there was a town or city in Bolivia next to the Salala River, it is undisputed that Bolivia would be allowed to use the water for human consumption. Bolivia could even build a dam and try to generate hydroelectric power from this river. It is also not disputed that the concession between the British company and the government of Bolivia has expired. So what do we do with this old legal document and differing descriptions of what's going to happen with this water source? Also, both countries agree that this is the most arid part of planet Earth, and that the Atacama Desert here desperately needs water, but it is probably too dry an area for agriculture, for much human habitation, or for use other than being drawn to the copper mine several hundred kilometers away. The University of Wyoming has a number of connections to this particular controversy. First and foremost, both sides in this case are relying on a book about Western United States water use. That treatise was written by the former dean of the University of Wyoming College of Law, named Frank Trelease. And he was essentially the guru of water law. And he developed important insights into how water is governed, allocated, shared, and used in dry, high plains situations like Wyoming and like the Atacama Desert. The doctrines and suggestions that Dean Trelease adopted are important and are used by water law experts the world over, including both sides in this particular case. Second, that British railroad company I mentioned earlier was intimately connected with and in fact became part of the Anaconda Mining Company, which has operations all over South America, particularly in Chile and in Colorado and Wyoming as well. The historic records of the Anaconda Mining Company are kept here on campus at the University of Wyoming at the American Heritage Center. And so researchers for Chile, in this case, have been poring over documents at our local archives to try to see if the river was treated as a river historically, or perhaps if it looked like a lake 100 years ago. It is fascinating that the records of the South American Mining Company would be at the center of a case being decided at The Hague that will clarify water use the world over. The third connection that we have to this particular controversy is through our faculty. We have a number of faculty connections to Chile and Bolivia, including international law relationships, academic research involving cross-border allocation rules, institutional adaptation, indigenous land and water use, desertification, hydrological change, and hydropolitical dynamics. Previous slide and this slide show my colleagues, Professor Brian Schumann and Professor Jason Robeson, experts in geology, climate change, biodiversity, and water law. And my colleagues have traveled to the region while I have been conducting international law research in Santiago in Chile. We have political scientists and geographers who are experts in Bolivia, and we look forward to rich further study and academic research of the many issues that flow from this case. Interestingly, when the case is heard at The Hague in April, it will be closely watched by representatives from the countries of Egypt and Ethiopia. Why? Because Ethiopia has built the Grand Renaissance Dam on the Nile River, and with that is interrupting the flow of the Blue Nile, which begins in Central Africa and moves through Ethiopia north towards Egypt. Egypt doesn't like that Ethiopia has dammed the Nile. Egypt and Ethiopia may go to war over the creation of the Grand Renaissance Dam. But the Chile versus Bolivia case involving the Silala River could interrupt the march to war between these two African nations if it can clarify exactly what is going on with water that flows from one country into another. And the reasoning of the International Court of Justice decision will be important. So, for example, if the court rules for Chile and says the reason that Chile can continue to use the Silala River waters is because it has always done so historically, then that will benefit Egypt, because Egypt has a treaty that gives it use of most of the Nile River waters. And as you know, it is the cradle of civilization, and so Egypt cares deeply about whether it will continue to have the same amount of water at the same time in the same way that it has utilized Nile River resources in the past. However, if the International Court of Justice decides that Chile can continue to use the water, but only because that constitutes a fair and equitable use, that same reasoning would apply to Bolivia. So if Bolivia wanted to build a dam to generate hydroelectric power, it could also say it is equitably using the water, and the downstream state, in this case Chile, would just have to deal with it. If that is what the court decides and doesn't focus on the history and custom, then that would favor Ethiopia, because Ethiopia would be in a position to say it is fairly using the upstream waters of the Nile, and it's important in the Horn of Africa to generate electricity. And so they want to use the Nile differently than it has been used in the past. And so the words of this decision will be closely watched by lawyers, politicians, diplomats, and even generals the world over. So with that, I invite questions to my email at the University of Wyoming College of Law. I thank you for your interest in this obscure international water law case, and wish you a great day. Thank you.